So we're gonna start from that will be study unit 4. So most of these things you'll see that we have spoken about them before. So it's gonna be more like revision as it is. So let's start with you guys wanna do a register for me, please? Register. Can you please do a register for me? Thank you. Okay. Okay, so for those that last time we spoke about the casebook, I was trying to get the third years to donate, but they don't want to donate. I tried my way around them. They don't want to donate, but I got a couple of them. They're selling them for most of them is 350. It's only one person that said 400. So if you do want, I can connect you with the person that has the casebook for that 350, or we can do whatever. So I was trying to get them to donate or to borrow us the textbooks because the casebooks, because they're obviously not going to be using them for now. So they just want to sell. Let's start with the definition of a thing as a legal object. Anyone wants to give it a try? Study unit 4, I think that's chapter 2 on the textbook. If you want to follow on the textbook. The definition in terms of its traditional characteristics. Remember what we always talk about in our sessions, the importance of the definitions. Sometimes a question comes, it asks you of something else. Am I audible without using the mic, right? Okay. But as long as you know the definition, you might be able to answer that particular question based on your knowledge of the definition. And don't be shy. There's no right or wrong answer. If you are wrong, we will correct you. Who can define a thing for us as a legal object? I know all your names by now, so I'm going to pick. Who wants to give it a try? Say at the back. No? Okay. Okay, so we have defined a thing as a legal object several times before. We said in terms of its traditional characteristic, it's a corporeal or tangible object that is external to persons, which is an independent entity subject to juridical control. Do you remember that? Okay. We even tried to break it down to find out certain meanings of the words so that we know exactly what we're talking about, right? Are we happy with that definition? It's on the textbook. You can either memorize the textbook, which will be difficult, but you can also write it in your own terms. So the whole purpose of us last time trying to break it down, trying to find out what is a corporeal thing, what's tangible, what's external to persons, independent, juridical control. I was trying to make sure that as long as you know what that is, then you can obviously answer better. So from that definition, there are certain characteristics that we call characteristics of a thing. And those characteristics, they are the ones that make up the definition. In specific crimes, that's how they teach us how to know the definitions. They give you the elements. Once you know the elements, you'll know the definition. So who wants to give us those characteristics? They are on the definition. One of them is corporeality, right? And then you look at external to persons and independence, and is subject to juridical control, and it's also valuable to humans. So your lecturer might ask and say, what are the characteristics of a thing? So once you know the definition, you know what the characteristics of a thing are because they are in that definition. So you can either learn to try to memorize the definition, which is the characteristics of a thing, or if you are like me, you learn in bullet points, you just memorize corporeal, external to humans, independence, subject to juridical control, useful and valuable to humans. You have your definition right there, right? Are we all good? We following? Okay. Can we move on to the next question? It says, I closed it. Distinguish between corporeal and incorporeal things with reference to practical examples. They will always ask you for examples. Sometimes when I try to be smart in a test or an exam, even if they said distinguish, if they didn't ask for the examples, I will throw in a couple of examples because sometimes the lecturers do give you like half mark or something like that just for exhibiting your knowledge. So I'm not saying that do that, but that's just me trying to fish for more marks because it's all about marks. So who wants to give us the distinction between, in fact, let's do the definitions. What is a corporate thing? Then if we know what a corporate thing is, what an incorporate thing is, then we know what the distinction between the two is. Who wants to give it a try? Corporate? Yes, ma'am. Tangible, right? Okay. Did we all hear her? Okay. Are we happy with the definition and the examples? Okay. Um, okay. So we can simply say corporate property, also known as tangible property, consists of physical objects that can be seen, touched, or perceived by senses, right? And then the examples that she gave, she said chairs, can be a car, it can be buildings and stuff like that. And then incorporeal, it's intangible property that lacks physical substance, like intellectual property rights. I think that's one of the examples that they gave on the slides. What do we have on question 4? What is an auxiliary thing? Guys, this is on the textbook. I think it's also on the slides. On the textbook, it's from page 18. You can read from the textbook as long as you give me an answer. Sometimes when you read it on the textbook, you might not forget that. Just because you read it, you will remember it, right? Let's not be shy, because if you're shy, I'm also gonna be shy. I'm actually the most shyest person in this room, I believe. What's an auxiliary thing? Gonna try, ma'am? No? Next to you? I don't think anyone heard you because of the noise. Oh, okay, it works. Okay, I don't think anyone heard you because of this noise. Do you want to speak a bit louder or should I give you a microphone? No microphone. Do you want to read it a bit louder? Okay. So what she said is that an auxiliary thing is a thing that exists separately and independently of the principal thing, but which, because of its economic value, destination, and use, is no longer regarded as an independent thing for the purposes of property law. And it needs not to be a real physical connection between the principal thing. So what would be an example of an auxiliary thing? Keys, you said keys and okay, tools, bar stools. Okay. They spoke about a case on your textbook, Senecal versus Roth. I think it's with reference to bar stools, but I don't think you need to know that for the purpose of that definition. Just if you have time, I think you can just throw it in there, but I don't think it's necessary for you to do that. When we say it's a thing that exists separately and independently of a principal thing, like a key to a door. So what we mean is that if you just have the key and you don't have the door, it's possibly pointless, right? But it works together. You need the key in order to open the door. Okay. What's an accessory thing? In fact, what's a principal thing? While we are still there, because they say it's a thing that exists separated, independent of a principal thing. What would a principal thing be with reference to that definition or to the examples that you gave? Okay, from the textbook, what is a principal thing? Okay, it says it's a thing which exists independently and which can, as such, be the object of a real right. What's an example of that can be an object of a real right? You will see that the textbook uses an example like a car, a laptop, or an electric drill, or something like that, right? So we say in our definition, we say it can exist independently of a principal thing. So now that we know what a principal thing is, and then when we use the keys and the car or the keys to a door, the definition will make more sense because now we know what it is that can exist independently from a principal thing, which can be a car for that matter, right? Does anyone have any question before we move on? Accessory things. What are accessory things? Yes, sir.
Principal thing is dependence, like big, building a house or
Okay. He says it's a thing that can exist independently, which has been merged. For example, a brick to build a house, or that has been used for the purposes of building a house, right? That was your example, a brick into a house. You can no longer go to a building and say this is a brick because it's no longer a brick, but it has become a house, right? Any questions on the accessory thing before we move on? Anything that you'd like to address from that study unit before we move on? Okay. Let's move on to property rights, real rights, and personal rights. In that study unit, there is a case that we have spoken about many times, I think, since the beginning of the sessions, which is the Ex parte Geldenis 1926 case. Anyone wants to remind us just the facts of the case? We don't need to know judgment and everything, just the facts. Anyone? Yes, sir. Okay, not necessarily for the loss. Did you say loss? They to compensate for? The facts just say that the one that got a part with more value, then you can compensate the others. I don't know if it's for the loss. I don't know if you read the whole case, if it does say that, I stand to be corrected. So they left land to their children, undivided shares, and then there were conditions that posed a problem, right? And then the Registrar of Deeds argued that the two conditions didn't create rights, therefore refused to register for them, right? And then what were what were the conditions that created problems? Do we know the conditions? Okay. Did we hear him? Did you? Okay. So the conditions, the problems were that it was specific conditions with regard to the time and the manner of subdivision of the farm. With regards to the time, it was that the farm had to be subdivided when the eldest son reached the age of majority. And the manner that it had to be done is that it had to be divided in equal portions by drawing lots. And the second condition was with regards to the payment of money. And the will stipulated that whoever draws the most valuable portion should pay others or compensate them a sum of cash. I think that's where we get the subtraction from the dominion test, right? Does anyone has a page number? 36. Okay. So the nature and effect of the obligation, that's how the formulation of the subtraction test. Ma'am, love this question. Yes, sir. The conditions. Is the time and the manner. Yeah. So the time was that the farm had to be subdivided when the eldest son reached the age of majority. And then the manner, it was how the whole thing would be divided, right? And then the second condition was with regards to the payment of money, that whoever got the most valuable portion should pay others. Yes, it's two conditions. Yeah. So the subtraction from the dominant test, we have very important aspects there. We say in order to determine if it's a subtraction from the dominant, we ask the question, does it limit or inhibit any entitlements of ownership? So we say if the obligation creates a burden upon the land, then it's a what? A real right, right? And then if it creates a burden upon the person, a personal right. Okay. And then, so you need to remember that subtraction from the dominium test. And please remember the facts of the case. So if you go on your study guide, there is a couple of cases, couple of similar cases, but the main case or the case that they deal with the most is this one. But it's not limited to, I'm not saying don't read on the Cape explosive case, and I think there's the other two. It's important that you know and understand just the facts of the case. Sometimes they can make a very big difference if you are given a scenario. Okay. Anyone has any question regarding that case? Just read that case. You don't even need to read the entire case, just the facts of the case, or on page 35, there is that gray thing on your textbook. You can just read there, and I think that should be enough. That information that is there, it should be enough for you to be able to answer a question that is given to you based on that on the drawing of lots and the subtraction of dominium test. Because in that instance, you will be able to understand when a real right is created and when a personal right is created, right? Can we get can someone give us the difference between real rights and personal rights and immovable property? We're just gonna soldier on with what we have. I'll try to use it. I know that it's a little bit distracting for you guys, but yeah, it is what it is. So the difference between what are real rights? Maybe we need to start from there. Yes, can you? The rights over a thing. Is that all? Who agrees with him? Ownership or limited real rights. But the question is, what is a real right? Let's, when you say it can be ownership or limited real rights. Or you were adding to what you said? Okay. Anyone else yet, ma'am? Okay. Yes, sir. Okay. Do you agree with him? A real right. It vests upon the person who owns the thing. Okay. Can we register real rights? Where it registers? I don't think for the purposes of the assessment you need to know the act, but I think you need to know that the real rights can be registered in terms of section 63(1) of the Deeds Registry Act, right? So the real rights, they bind the successors. This is not nice. I wish we got a different venue. And the personal rights. Let's talk about the personal rights. So, okay, another thing is that the real rights and the personal rights are both constitutionally protected. We spoke about constitutional protection previously. Who remembers when we say something is constitutionally protected? If you say, I own a house in Potchefstroom and it's constitutionally protected, what are we saying? Yes, ma'am. Yes, from what we discussed. You cannot do with that thing as you please. Okay. So when we're talking about constitutionally protected rights, let's say, for example, the right over your property. I hear what you're saying, but I think please don't confuse yourself to go that route, right? We gave an example of a house, people with their houses in Rosebank and Sandton during 2010 when they were building that train thingy. We say that their housing, their rights over those properties were constitutionally protected because the government can't just take away their property just because they're trying to build a train station, right? So there is certain rules and procedures that needs to be followed. Okay. I don't know how we go there. The personal rights. What are the personal rights? Yes, sir. Yeah, that's correct. Anyone else want to add? Okay. The personal rights are enforceable only against a person who is expressly agreed to them or who is obligated to fulfill them. So from there, we can use an example of a contract. Are you okay, sir? At the back there. Are you good? Okay. So for personal rights, we can use examples such as the contracts, the lease agreement, stuff like that, right? Let's move over to ownership. Who can help us with the description of nature and the content of ownership? Ownership. What is ownership? Yes. It's a lawful real relationship between a legal subject and a legal object. Okay, as simple as that. There is a case as well with reference to the definition of ownership. Kin versus kin. Who remembers the facts of that case? The story surrounding that case. Let's call it the fact. Let's not call it the facts, because when we call it the facts, we formalize it and then it sounds a bit difficult. Anyone remembers the story around that case? Yes, sir. Okay. Did you all hear what he said? Okay. And the last part you spoke of an internet. What is the internet? It's something that you the remedy. Yes, to somebody to stop something, right? Or to do something, right? So we do have the requirements of a remedy. What are the requirements of a remedy if you want to institute? Yeah, anyone? Yes, Hanif? Must be
There must be an actual violation.
actual violation of the right, yes. Okay. A clear right. Yeah. Okay. So those are the requirements of an interdict: a clear right, actual or reasonable apprehended violation of the right, and there must be no other remedy. Okay, move this guy away. So in terms of kin versus kin, what is the definition of ownership? You did give us the definition of ownership, but from the case kin versus kin, if ma'am ask the question and say, from kin versus kin, what is the definition of ownership? What would you say? Yes, sir. Okay, the most comprehensive real right that a person can have over a thing. Okay. So when we're talking about ownership, there are two aspects that needs to be taken into consideration. Very important aspect when it comes to ownership. Who knows what those are? The two aspects when we're talking of ownership. I can give you one, it's entitlements. And the other one, ahead, limitations. Yes, don't be shy. And limitations, right? What are the entitlements of an owner? We have about 5 or more. Yes, sir. So we say control, to use, to encumber, to alienate, and to win, right? It's how many are there? 6. And the limitations to ownership in public interest. Who knows the limitations to ownership? Territorial limitations. Okay. Please remember the entitlements of an owner, right? I don't know how you would try to memorize them, but they're very important. The limitations on ownership in public interest. I think I saw something like that on your textbook as well when I was making my notes. So there's the economic interest of owners. The economic interest of owners must be weighed against the interest of the community. And then we also have legislation, the PIE. The interest of landowners must be weighed against the interest of unlawful occupiers during eviction process. I think there's a lot of interesting cases on that note. And then the landowners' entitlements can be limited in the interest of nature, conservation in terms of the Environment Conservation Act, right? So is ownership absolute? No, you said no, what? Come on, wake up. Because of the limitation. So the answer should take us back to the case of Guinea versus Guinea. So if they do ask you that kind of question, so your answer must always go back to that case, because that case is the one that speaks on that ownership is not absolute, because what Guinea versus Guinea says, the person that installed apparatus and everything says, I can use my property the way that I want, right? And I can do whatever I want without considering the neighbor and the animals and the people that live in that property, right? So your answer must always go back there. You must always use that case as a reference, that you, although you have the right to use your property as you wish, but it must be used so in a reasonable manner, right? I remember she gave us an answer at the time, and she used the term tolerant and expanded on that. So in terms of ownership, does anyone have any questions? Anything that I out here, or anything that I needed to add? So are we happy with the definition of ownership, right? Are we happy with the case Guinea versus Guinea? Understand? So if they say discuss that case, you know how to discuss it. If they ask for the facts of the case, you know how to do that, or in terms of application as well. But in most cases, it comes as the definition, or maybe just to discuss the case. And please remember the requirements for interdict as well, very important. The two aspects that needed to be taken into consideration when it comes to ownership, that is the entitlements and the limitations on ownership. He gave us the entitlement of ownership, which is entitlement to control, to use, to encumber, to alienate, and to vindicate. Okay, it's also on page 54 on your textbook. So yes, ma'am. The requirements of an interdict. Okay. Number one, there must be a clear right an actual violation of a right. And there must be no similar protection or any other ordinary remedy. Similar protection. So if there is no other remedy. So in most cases, interdicts are usually urgent matters. So if something is urgent, it means that normally it will mean that there is no other way except to get an interdict because it's the one that's faster, right? Yeah, today we are surviving. Yeah, anyway. So I was trying to go back to the entitlements. So you will see on the textbook, they kind of a little bit expand on the, like, for example, the entitlement to control, the entitlement to physically control and to keep a thing, right? And then the entitlement to use is the entitlement to use and benefit from a thing, right? To encumber, the entitlement to grant limited real rights in respect of a thing. And then the entitlement to alienate is the entitlement to transfer ownership of a thing to someone else. And to vindicate is the unique entitlement of an owner to claim a thing from another person. Sorry, guys, let me quickly check this. It must be an emergency because it's been. It's. Anyway, sort of that. It's one of the process. But okay, let's continue. We are happy with the entitlements of an owner, right? So if they say entitlement to control, you will know what that is, right? All of them, very important. Let's go to co-ownership. Co-ownership, what is co-ownership? If I say that I'm a co-owner of this textbook, what exactly does that mean? Yes, sir. What's your name again? Your name? Yes. Kevin. Okay, Kevin. Yes, sir. Two or more people? Only anything together. At the same time. Okay. Anyone wants to add? You want to add? Okay. There are various ways that co-ownership can be established. Right? We know that, right? Do we know how we can establish co-ownership? Yes, ma'am. Let's start from inheritance. Okay. So from marriage in community of property. Okay. We had another hand. Someone. Mix it. Yes. He said ownership. Okay. You are very quiet today. You are very quiet today. What's up? You're good? Okay. All right. The last one. Voluntary association. Yeah. Yes, voluntary association without legal personality. Okay. So those are the ways of establishment. You can find those on the textbook. it's page 64. Okay, she said by contract as well. See the contract thing. Okay. When we say inheritance, how do you establish co-ownership by means of inheritance? Who said inheritance? Let's go big. Yeah. Yes. Okay. Yeah, that's correct. So just to expand on that, let's say, for example, I used an example of my textbook that says I leave my textbook to you and him, and then you guys become co-owners of the textbook. Do you remember that? Okay. Marriage in community of property. Why in community of property? Yes. Like what's mine is yours, what's yours is mine, belongs to us, right? Okay. So we have types of co-ownership. How many do we have? Types of co-ownership. How many do we have? Two types of co-ownership, right? We have, what are those anyway? Let's start from there. Free ahead, free, yes, and bound, right? And then what is bound co-ownership? Seven.
In bound ownership,
Yes.
it's whereby if a person wants to sell his or her part portion of the thing that he owns, he needs consent.
Of the other party. Okay. So so now let's start on what is bound co-ownership before we go to the implications. That falls under the implications, but we are not wrong. Yes, yes. Okay, you go first, man.
Their relationship in that they cannot terminate their co-ownership while that underlying relationship still exists.
Okay. So you forgot the most important keyword there. Legal. Right? Yes. Yeah, that can make you lose your marks. Okay, that keyword is very important. She says when there is underlying legal relationship, such as marriage, right? You had your hand up, sir. That's what you wanted to say. There was another hand. There's another hand this time. No. Okay. So when there is an underlying legal relationship, such as a marriage and common of property, you already gave us an example why in common of property, because in common of property, what is mine become yours and so on, right? And another example would be partnership. So what is free co-ownership? Free co-ownership. When we say it's free co-ownership, yes, ma'am. Okay. There is no underlying legal relationship between the parties, such as friends, right? If we are friends, we don't have an underlying legal relationship between us or brothers, right? So we are right on time and we are almost done. Are the implications of bound and free co-ownership? What are the implications of bound co-ownership? I think Kevin was trying to give us the implications of bound co-ownership. Kevin, you want to the implications of bound co-ownership. You were coming right with the implications. Okay. So with bound co-ownership, a co-owner cannot alienate or encumber their share of co-ownership. What did we say alienate was in terms of property law? It's one of the entitlements. Yeah. You say transfer. So they can't transfer it. So if we are married, if we are married income to property, I can't transfer that property to somebody else or to sell it without the consent of the other party, just like you said, right? And to encumber, what was our yes, sir? To do what? To pay. To grant limited rights. Yes, yes, of the thing, right? So please, like I said, when you know the definition of whatever question that is posed to you, definitions carry that weight. So when you know the definitions, you'll never go, right? So okay, we're still on the implications. We said a co-owner cannot alienate or encumber the share of co-ownership. The underlying relationship determines the joint exercise of entitlements, and then the co-ownership cannot be terminated unilaterally while the co-owner relationship still exists, right? So those are the implications of bound co-ownership, right? Are we happy with those? Do you have them down? Okay. And then lastly, the free co-ownership. What are the implications of free co-ownership? Second, the opposite of the other one. Yes. They can alienate, they can encumber, they are undivided share independent, right? And then the underlying legal relationship doesn't determine their joint exercise of the entitlements. And the co-ownership can be terminated unilaterally. I can wake up in the morning and be like, hey, I don't want to do this anymore. But if you're married, you can't do it, right? So okay. So just a recap on the things that we touched today. Are we happy with the definition of a thing as a legal object? Are you guys sure? Today you guys are worrying me. Is it because of the case that are coming, you're not getting enough sleep? You must get as much sleep as you can, right? And the characteristics of a thing, we still remember them. We didn't write them down. It's corporeality, external to humans, independence, subject to juridical control, useful and valuable to humans. If you know those characteristics, you know the definition in terms of the traditional characteristics, right? We did the difference between corporeal and incorporeal things with practical examples. We know now what an auxiliary thing is. We know what an accessory thing is. You know the ex parte held in this case. The subtraction from the dominium test. Okay. Ownership, gain versus gain, the entitlements and the limitations, co-ownership, ways of establishment, bound co-ownership, free co-ownership, and the implications. So if the paper comes exactly like this, we've got 100%, right? Okay. Thank you so much, guys. So I will communicate with you on the group. I don't know what your schedule is like. For tomorrow, we can try to squeeze in another session. We can do it online. But then on Thursday, we're going to be, I don't know what the venue is. I think it's the one next door or the one that's, but it's there on the group. There's something else. Okay. So one more thing. So tomorrow we have a meeting, what that I announced in class that day with the director of undergraduate. Let me just stop this because I'm recording this as well. Just stop recording.